on www.AfternoonswithMonique.world.
Hello.
Is Justice Sander on?
I'm here. Can you see me? No?
We're waiting for Justice Sander to join our Zoom link.
Hey, Adina.
So let's give him a minute.
Hey, wait a minute.
Justice Sander, are you there? Can you see me?
Just a minute.
You are on Afternoons with Monique. I'm Monique Lee. We're waiting for Justice Sanders to come on the live screen.
Can you see me? Can you hear me?
Good afternoon. So I'm going to give him a quick introduction. This is Rainier Avenue Radio. You're on Afternoons with Monique. I'm Monique Lee, your host. And today I invited on our show a very special person about Washington State. He had served on the bench for over 15 years just on the Supreme Court, and was a lawyer and is a prolific writer of judicial opinions. He had written many concurring and dissenting opinions that had been talked about by the people of Washington State. And today I have the honor of having on my show the Honorable former Justice Richard B. Sanders. Justice Sanders, can you hear me?
Yes, I can very well.
I think you may be on mute.
Maybe. Adina?
I can see you, but I cannot hear you.
I'm trying to find the mute here. She says I'm on mute. Just a minute.
Okay, you see this? You shouldn't be on mute.
Can't hear me, I suppose.
Oh, okay, so me.
I'm not hearing him for some reason.
I can hear you. Can you hear me now?
Oh, now I hear you. Yes, that's
good.
Very okay. So Justice Sanders, welcome to the show. Thank you for joining us today.
Well, thanks for inviting me.
Yes, I don't know if you've heard, but I had a chance to introduce you to our guest on the show today. You are a former justice of the Washington State Supreme Court for 15 years. And so in those years of practicing law and jurisprudence, there are a lot of knowledge and experience that we would like to learn from and about you today. So can you share with us a little bit about yourself? I made the introduction, but please, let's hear from you.
Well, I graduated from the University of Washington Law School in 1969. So now that was 51 years ago. So the highlight of my career, of course, was serving on the Washington State Supreme Court. I had practiced private practice mostly for 26 years before I was elected to the court.
Mhm.
And after I did get elected, I probably sat on 1,700 cases, wrote opinions in 600 or 700 of them. And it was the experience of a lifetime. And I enjoyed it when I was there.
Right. How many cases did you say you looked at, and then 700 of decisions written? Is that right?
Yeah, I probably sat on 1,700 cases
Wow.
during the time that I was there. And the court has a way of divvying these things up. So there's sort of a ceiling on majority opinions because everything is pre-assigned to a justice randomly. And
Right.
oftentimes the assignment justice ends up with the majority opinion, although not necessarily so. So so you divide 1,700 by 9, and that's kind of where you start off with the case to which you're assigned.
Oh, I see. Okay. So I read somewhere that you hold the record for dissenting opinions, and much ink had been written about your conservative position on the Supreme Court. Can you tell us about this record of dissenting opinions?
Yes, well, I did not go along to get along. I thought I was an independent jurist on the court, and I had a responsibility to do the right thing, to follow the law in every case, and to support the rights of the individual in every case. And if I thought my colleagues were wrong, or a majority of my colleagues were wrong, that I would be willing to dissent, or maybe sign someone else's dissent, because the most important thing is getting it right, not being in the majority. In fact, in one case, it's an oddball case, but I even dissented from my own majority opinion. That's how many dissents I had.
What was that case about? You write your own opinions and then you dissented.
Yes, that was a double jeopardy case. And the state argued that the defendant's rights under the double jeopardy clause were not violated. So I wrote the majority opinion, in fact, a unanimous opinion to that effect. And then the accused came back with a motion to reconsider and persuaded me that I was wrong. So I persuaded the court to reconsider, which doesn't mean they changed their opinion, but just that we would have a new hearing. So that's what we did. But at the end of the hearing, I was in the minority. So the majority justice, it was Justice Charles Johnson, said for his opinion, we adopt the last opinion of the court, which was my opinion. So then I had to dissent to my own opinion.
Right.
That's okay. You know, that's the way it ought to work.
Right.
I don't want people to go to prison because of vanity, or that I wanted to write the majority, or I wanted to get reelected or something. That's not the way it should work.
Well, we live in a liberal state, and you definitely stand in the minority in that regard, that you have conservative positions when it comes to Second Amendment, gun rights, and property ownership, same-sex marriages, or and pro-life, pro-choice kind of position. So that must not be a popular place for you to be. However, you seem to hold your stand quite firmly and able to defend those positions to much oppositions. And I've read about that online and whatnot. How are you today, now that you're off the Supreme Court? Are you still pretty strongly held onto those positions today?
Well, first, I would consider myself a libertarian, not a conservative. And a libertarian believes in limited government, believes strongly in civil liberties, in the rights of the accused. And all of us have many civil liberties. Depending on our station in life, some are more important than others. But to the founding fathers, all of them were important. And it's sort of a trade-off, I think, that you get yours, I get mine. And that's the way the system ought to work. So I'm for freedom for everybody. How's it been since I left the court? Well, I was disappointed. I lost my last election, but I got over it. And now I'm back in private practice, and I'm looking at the court system again, the way it really works at the trial court level and on some appeals. And it's enlightening. So it's a different role that I play now, but I'm still a lawyer, and I'm enjoying myself.
And are you practicing in King County?
My office is in Tacoma,
Oh, okay. So Pierce County.
Pierce
Pierce
County.
County.
Right.
Pierce
Right.
County. Right. Um, well, I like to find out a little bit more about your different decisions. Which one would you say that were some of the decisions that you're most proud of?
Well, in reality, I guess I'm most proud of some of my dissenting opinions, because when you write a dissent, you don't have to please anybody but yourself. So, so I remember one of the very first cases I heard on the court was a challenge to the three strikes you're out initiative. And the individual, a young black man, had been charged with uh, robbery of an espresso stand of $300, armed with a finger in his pocket. So, and he got life without possibility of parole. And 7 members of the court affirmed that sentence, that he would go to prison for the rest of his life for stealing $300 armed with a finger in his pocket. I thought that was a cruel punishment, unconstitutional punishment, and I dissented. And
Right.
you mentioned before that I was identified as a conservative, and I think that's true. Some of the most conservative people in the state were avid supporters of the three strikes you're out initiative, and of course I alienated some of them by deciding the case the way I did, but I thought it was the right thing to do. Another case involved also a black man in Spokane, and he was pulled over for not signaling when he changed lanes
Mm-hmm.
and arrested. It was a false arrest because that's not something for which you can be arrested. But the police descended on him and beat the tar out of him. He couldn't be checked into jail because he was too badly beaten. They had to take him to the hospital,
Mm-hmm.
and then they charged him with resisting arrest. So he was convicted. That went up to the state Supreme Court, and a majority of the court overruled 500 years of precedent, which said anyone can use reasonable force to resist an unlawful arrest. So I wrote the dissent saying exactly that, and my political opponents characterized me as being soft on crime, or one prosecutor said I was a criminal's best friend. And I remember that was an election year, or close to an election year, and I remember going to Spokane, talking to the police officers guild and thinking to myself, well, maybe they're going to knock my head off. But they were very nice, and I explained the case and my reasoning, and we got along great. But that's I dissented in the medical marijuana case, where this man was dying of cancer and he wanted to smoke marijuana to make him feel a little bit better.
Right.
And once again, that was a 8-1 case. I wrote the dissent. I said he has a right to medication. It violates his right to due process to be denied the medication of his choice. Many different cases were decided, and some of them, I suppose, that your listeners might characterize as liberal. Some of them might characterize as conservative. But for me, the focus was always the individual who was there in court and trying my very best to defend his or her rights.
Right. And I see that the reason why you are proud of these positions is because they were not popular position to hold with your fellow Supreme Court justices at the time. And so in order to dissent or to write against the majority, it would take a certain amount of courage and fortitude, but as well as personal conviction and strength from your end. So I can see why you find that something that you would be proud of. How about the most important Supreme Court decision that you contributed to Washington State?
Well, on one occasion, I was able to reverse a death penalty for someone. I can't even remember his name right now, but he would have been executed but for my opinion in that case. And we determined that he had been badly beaten as a boy by his father. His father would put him in a cage with literally wolf dogs. I'd never heard of a wolf dog before.
Wow.
But it was a horrible, horrible experience. And he had lesions on his brain as a result of these beatings as a
Wow.
child. And that was, in my view, that was a descent. That was a factor to take into consideration when administering the death penalty. So I saved a life.
Right. That's
That's important.
exactly what you did in that case. Wow, that's somebody's life could have been destroyed because of that. So thank you for that. What lessons did you learn from being on the bench?
Well, I think my criticism of the judiciary in general is that it is much more too favorable to the government position. I think that, our state constitution says the very purpose of our state government is to protect and maintain individual rights. And that's what I tried to do every day when I was in court. And I believe that some judges think that the government is a wonderful thing and we have to stick up for the government and give the government the benefit of the doubt. But I view civil liberties just exactly the opposite. That our civil liberties should take precedence over any governmental interest. So that's something I learned. I think that returning to private practice, I recognize some other problems I think the judiciary has. Like there's a lot of lying, in the courtroom, and
Right.
very few times are people prosecuted for perjury or lawyers disciplined because they lie to the court. And it takes a strong trial court judge to do something about it. And I think that I would hope that they would do a better job at that.
Right. Well, right now, a lot of people can perjure and get away with it, and I don't see a whole lot of enforcement of the law in that area. And I'm actually surprised that as a former justice, you can see that, but yet, well, I'm sure you must have seen that when you were practicing and were on the bench after 20 some years of practicing as a trial
Yes,
lawyer.
when I was a young lawyer, I was sometimes appointed to represent indigent criminal defendants in criminal cases. And I
Mhm.
remember one such appointment. It was a drug deal in the Whirlwind Cafe on Yesler Street. I don't know whether the cafe is still there or not, but there
Yesler?
was an undercover black policeman who was posing as a pimp and a facilitator to the drug deal.
Mm-hmm.
And he testified that he saw my client exchange drugs for money with the co-defendant. And he indicated where they were, and he said he had a perfect vision. Well, as it turned out, 3 or 4 years prior to that transaction, the proprietor of the restaurant had built a concrete wall between where the officer said he was standing and witnessing the drug deal and where he said my client was sitting. So, that was a lie. And
Right.
the prosecutor knew it was a lie. The judge knew
Right.
it was a lie.
Mm-hmm.
And there was no consequence.
Right. So you're on Rainier Avenue Radio. This is Afternoons with Monique, and I'm Monique Lee. We have Justice Sanders of Washington State Supreme Court on the show. He's a former justice right now practicing law in Vashon Island. And I wanted to move to, actually, before we move to the election, I want to ask your opinions about the elections in Washington State Supreme Court. But I want to know what, in 1 or 2 words, what would you call yourself? What name would you give yourself as a judicial philosophy? Are you
Well,
a textualist?
I think I'd be a textualist.
Uh-huh.
That's a term that Justice Scalia popularized, that
Mm-hmm.
you start off on any legal problem by,
Right.
if it's a statutory problem, you read the statute, you read the words.
Mm-hmm.
If it's a constitutional problem, you read the words of the Constitution. And whatever you do in the final analysis has to be consistent with those words. and that's the most important thing. We're not worried about the spirit of the times. We're not worried about social problems. We're worried about making sure the law is properly applied to the individual that's before the court. So that's the way I look at it.
Right. So is there a member of the U.S. Supreme Court, a current justice, or someone served in the last 40 years that you consider yourself, you share this judicial philosophy?
Yeah, I think Clarence Thomas is a good example. And I would, although some of his opinions I don't agree with, but I think in general he has the right approach to things, and some of his decisions are pretty original and pretty inventive. And I give him my congratulations.
All right. How about this Washington state election? We got 2 Supreme Court justices seats being contested, and I'm aware of a couple in King County's Superior Courts. What do you think of these races and the candidates?
Well, I, like most of your listeners, probably are ill-informed. I would start there. I know the contest between Justice Montoya Lewis and Judge
Dave Larson.
Dave Larson. I know Dave Larson. I followed his career for a long time, and he's very experienced. I don't know Judge Montoya Lewis. I've never met her. I'm not really familiar with her record, although I did listen to part of the interview on your program, and that was a public service I thought was very interesting. As to the other race, Judge Whitener presided over a motion calendar where I was present in Pierce County, and she seemed to be up to speed. She was articulate. She had read all the papers and offered an opinion in each case that seemed to be based upon the facts and her research. So good for her. I just don't know anything about her opponent. So there you are. Let the best man or woman win. I guess the show's over, huh? Well, she's no longer on the screen. Just
Hit
gonna
play there.
here.
Yeah. Should have shut the curtains.
Escape. Guess it's over.
Sorry about that.